October 12th, 2020 to order. Just for the record, Madam Clerk, will you call the roll, please?
You're muted, Robin.
Sorry about that. Mayor Pro Tem, District A.
Here.
District B.
Present.
District C.
Present.
District D.
Present.
And Mayor Hawking.
Present as well. We have many things, item 3, to be thankful for, and we'll always acknowledge that. Is there anyone on item 4 signed up or online to speak? Kyle.
Mayor?
Yes, Mr.
This is-
Compion, how are you?
Doing well, Greg. Thank you. I do just have a moment, if I could. We had postponed our presentation from the Marque Beautiful Commission, but I wanted to just indicate that the commission has received its second place award from the Governor's Community Achievement Award. I don't know if I'm able to show this online to the council members, but if you see it, there it is.
Yeah, we see.
I want to thank the dynamic, and I have to say that, the dynamic members of the commission for all their work. One of the bases for this award, and I have to be very clear, is when I presented this award, I stressed the diversity and the great relationships that we have in this community of all of our community members working together. And we're going to do some dynamic things to submit an award application this year as well that I think the community will be proud of. And we're going for #1 this year as we've continued this effort. And that's all I want to say. Thank you to the dynamic commission members, and thank you to all our city council members and you, Mr. Mayor, for your support that you've given the commission over these many number of years.
Thank you, Joe. We appreciate that, and congratulations to everyone. Anyone else wishing to speak?
I would like to.
Yes, sir.
Yes, I just want to say that in these days and times of politics and government, I would like to just emphasize that ethical behavior must be the top thing that we do. And every city official, whether you're elected, whether you're appointed, whether you work in the city government, that those ethical considerations be done in everything you do. And just want you to know that we are watching and looking for those ethical issues. Thank you.
Thank you. Appreciate that. Anyone else? Hearing and seeing none, we'll move to the consent. Mr. Jackson for the workshop.
Mayor and City Council, good evening. First item on the consent agenda is item number 5A, which is discussion relating to ratifying city manager's expenditure of $66,930 from the CARES Act funding for protective masks related to COVID-19. This is not technically required under our city's procurement policy, but we just figured if council ratification, even though you'd already approved the budget, council ratification of this would make it a lot cleaner when we submit it for the CARES Act funding. So if anybody has any questions on item number 5A.
Yes, I do think.
Go ahead.
Ready?
Yes.
Okay. I'm going to try to go as fast as I can on these questions so that we can get done and get it over with. In your information, you said that you adjusted the purchasing authorization levels to the trigger point. Could you help us to understand what you mean by the phrase trigger point and how you had to adjust it?
Well, so normally, if we're going to spend over $50,000 on an item, then we get council pre-approval before we do that. In this case, we started ordering masks, not knowing what the extent of the pandemic was going to be or how long it was going to hold out and how long we were going to give those masks out. So as we continue to pass out free masks to the public and continue to had to reorder, with this last order, we hit that threshold. So that's why we brought it back to council.
So you said you adjusted in this policy, you adjusted the level of purchasing authorization to, and then you use this phrase trigger point. And what is that?
I think that's a different item that we're talking about. You're talking about the new procurement policy?
Yeah.
Yeah, that's a different item. Right now, we're just talking about the approval of the purchase of all the masks that we've done for COVID-19.
No. I'm sorry. Oh, okay. I got you. I'm on the regular agenda. I got you. You're on the workshop. I got you. Hold mine for that topic. Thanks.
Okay. Any other questions under 5A? Okay. Seeing none, we'll move on to item number 6A, which is discussion relating to adopting ordinance number O-2020-0015, amending Chapter 2 Administration, Article 4 Purchasing of the Code of Ordinances for the City of Lamarque, Texas, and adopting and updating procurement policy. So this one is the one on updating the procurement policy. I'm going to ask our city attorney to give a synopsis on this, and then you can direct whatever questions you have as soon as she gives her synopsis. So Dara, why don't you go ahead?
Thank you, Mayor and council members. As you know, when we go to apply for grants, we're often asked to adopt an updated procurement policy. Now that you have in-house counsel, I worked with the grant administrator and said, we just adopted one of these in February of 2020. If you recall, we had to do that fairly quickly to make a grant deadline, and we didn't get to go through that with as much detail as we'd like with the finance director. So this policy in front of you, we actually got to do that. Still a little bit rushed, but not nearly as much as last time. So one of the things we did is the bulk of your procurement provisions in Article 4 and Chapter 2 were not updated since about 1972. So as Mayor Pro Tem Bell was speaking, there are some trigger points that have changed over the years in state and federal law. For instance, the formal bidding process is required unless the procurement is exempt at $50,000 under state law. Underneath that, it's just subject to your procurement policy. At the federal level, at the $3,000 mark, you're required to get bids to reach out to the list of historically underutilized businesses, women and minority-owned businesses on both the federal lists and the state comptroller's website. So that $3,000 is one of those trigger points. $50,000 is a trigger point, et cetera. And then in the federal side, you get up to some higher numbers. 150,000 starts to trigger additional requirements. So one of the things that we are suggesting that's probably the biggest change in here is updating your authorization levels, meaning at what point do you need more than finance director approval? We're talking about over 3,000, you need city manager approval, which means that anytime the city manager gets a request for approval of a requisition, he can also ask the question, have you contacted historically underutilized businesses in compliance with federal law? At the 50,000 mark, it's going to have to go to council for approval, and it's going to be required to meet those formal bidding requirements or show proof of an exemption. And so these are some big changes that actually help ensure compliance, but they also lower some of the liability that the city is exposed to, because to that extent that we had a difference between the state procurement limit at 50,000, we were adding additional requirements for any procurement between 25 and 50,000. So we're really lining up a lot better with the state and federal law, since we're doing a lot more of those grant procurements, and that really lets us streamline some of that.
Good evening, dear. How are you?
Good, thank you. What can we do for you?
A couple of things. So these trigger points, basically, from listening to you, are these financial numbers that run consistent with state law, with federal law. Is that what I'm hearing you say?
That is correct.
Okay. How long has, really quickly, because I want to just establish something here. how long has that number for council approval been at $50,000?
You know, I couldn't tell you that off the top of my head. I can get the answer for you pretty quickly. It has been for quite some time. I know that the council has had that 25,000 limit since the 50,000 has been in place. But I also know you've gone through quite a lot of changes.
And you don't need to go get the number. That was the point that I was trying to make. Not this council, but previous councils that I've been a part of thought it, and I'm not suggesting that we continue on with this in this way, but they thought it's important enough to leave that at 25,000 because they wanted to make sure that they had, in their opinion, the appropriate oversight over the financial health of our city. And so that's just information for those members of our council that are new, that have been here a term or two, so that they'll see what that was about. But let me ask you really quickly, I want to get into a couple of other things. This $50,000 number, and this is important, is that a number that is basically concrete in state law regardless of the size of your municipal budget? In other words, is it 50,000 for a budget our size as well as 50,000 for a budget the size of City of Houston?
Correct, it is. Now, I will clarify that Houston, as such a large city, does have certain provisions of state law that are specific to them or to those really, really large cities. So I, not representing Houston, I couldn't tell you off the top of my head if they have some special provisions. It would be common, but anybody under that size is subject to that universal 50,000 limit.
So let me ask the question again, just really quickly. I'm just trying to establish some things. So you're saying that every purchase the City of Houston approves for a minimum of $50,000 has to go before that council. Doesn't matter to me. I'm just trying to establish and understand.
So not using the City of Houston as example, but League City, anything that happens that is over 50,000 has to go to their council. And if I could make one clarification, one important part to this procurement policy that I think does speak to some of what you're talking about is that the limits of the $3,000, the $50,000, where those can be procured without council approval, they still have to be in compliance with the purchasing policy. And that means that only applies to budgeted items. So anything that is not budgeted, even if it's just a few dollars, would still have to come to council for approval. The idea being that council's already approved those line item budgets. So it's not that you don't have any oversight. It's just that so long as the purchase is in line with what's been budgeted, it doesn't require an extra step.
And so I just wanted to compare apples to apples and oranges to oranges. $50,000 as a percentage of our budget is significantly more than $50,000 as a percentage of Texas City's budget or League City's budget. And so I want the council to have that information in their minds as well. Does this, really quickly, two more questions. Does this have anything to do with our bid policy?
Your bid policy?
Right. As far as what triggers, if you would help reacquaint us with this, what triggers the administration to have to provide this council with 3 bids? At what spending amount is that triggered?
So right now you have it set that the formal bid process is required for anything over 25,000. Under the new policy, you would still be asking for quotes, but it would not require the formal bid policy, and that is up to 50,000. So what we're doing there is we're changing when you have to go out for the full-blown RFP with newspaper notification, etc. We're not necessarily doing away with the quote requirement, and federal law does take over for anything over the 3,000. So what we're trying to do here is really make sure that with all the grant purchases, some of those requirements that aren't maybe typical for most cities, that those are remembered on every single purchase, like the historically underutilized businesses being contacted.
So just to drill down on that really quickly, this council would still, for anything above $25,000, would this council still, even though the bid process has been changed to make it more efficient, we would still have to vote to approve those quotes? Is that what you're saying?
No, so you would still require the 3 quotes. And honestly, that's for anything over 3,000. We're requiring quotes under the purchasing policy. So you're still requiring efficient stewardship of the city's money, making sure that, there's no favoritism, that sufficient numbers of quotes are supplied to the finance director and part of that purchasing package. The council would only have to approve any purchase over 50,000 unless it was an unbudgeted item.
Yeah, I don't know that. So in other words, anything under $49,999 becomes a no bid contract.
So yeah, no formal RFP or bid process. It doesn't mean there's no quote or no requirements applicable.
It takes the council completely out of this process.
Only to the extent that you've already approved the budgeted line item.
Okay. I don't know if that's something. I don't know yet about that. I'm really nervous about that. Really quickly though, part of this presentation says wherever possible, historically underutilized businesses shall be included in solicitation lists for the bid or non-bid purchases. There is supposed to be somewhere, and I don't know that it's not, there's supposed to be somewhere some sort of list that has every historically underutilized business that wishes to do business with the city of Lamarque. We're supposed to have that in our possession. Is that what I'm understanding or no?
Not exactly, because it does change on a regular basis. I actually contacted some today, so I can tell you. Basically, if you go to the Texas Comptroller's website, they keep the active list for the whole state. You have to run a search for Galveston County, and then you can drill down into the specific type of service that you are looking for. And there's quite a lot of detail there. I was able to find historically underutilized businesses for some unusual items. That is not always the case. And that is where that language comes from on the federal side, is the wherever possible, because there are certain purchases that are exempt, or there are purchases where, there's not a historically underutilized business vendor for that purchase.
Last question. Have you seen, I know you've only been there a short time, and I'm just asking the question. I'm
Sure.
not trying to say anything. I'm just curious. Have you seen evidence of our ability or the attempt of our municipality to engage historically underutilized businesses within our city?
Have I seen evidence that we've done that?
That we've done it, or that we've tried to attempt to do it?
Yes, absolutely.
Okay, we'll talk later. Thank you.
Okay.
Dear, thank you for bringing this ordinance up. It mirrors very similar the corporate world. If you want to do business with the federal government, or in our case, applying for grants, you must follow all these guidelines. So thank you for updating us.
Thank you. And just to point out too, when we get to this item, there is one minor correction. There were a lot of 2s in this ordinance. So when we get to it on page 6 under micro purchases, the first sentence says $2. It should say $2,999.
Correct.
I was hoping, so the biggest note I had under this one was just if you would walk us through the most salient, biggest impactful changes that you're hoping to get from this change.
So one, we need to update a procurement policy anyway. There's been just a few minor things that have happened since February of 2020 that the grant administrators were asking for. So these are some federal updates. There's also, I noticed that, like I said, several of your procurement provisions had not been changed. So I think of this as kind of a dusting off. When we adopted the one in February, we just made it cumulative with the provisions in Article 4. That's not necessarily the cleanest, most consistent way to do it. So I'm also hoping to really see that. And then the change beyond that is a change to these authorization levels. I do see that some of the procurement gets very slow. And I think trying to put these kind of what I call mid-range purchases that are, I don't see a lot that are over the 40,000 range. These are usually things at about 30 to 35,000. Emergency purchases in public works. Now, if it's not budgeted, it'd have to come to council anyway. But that's really kind of slowing down how some of the departments can work. And then the other issue is, to the extent that your purchasing policy requires, council approval and the formal RFP process for those purchases between 25 and 50,000, we do have some potential liability for, anyone who's a bidder that doesn't get that bid, and we're kind of adding it to ourselves. So from that perspective, that's where I really come up with that 50,000 number. I will tell you, I've done some work with some water districts that had a much higher number, and that even worked fairly well, because water districts are not under the same legislation as cities. So over time, they've been moving it higher and higher and higher. So I do think the 50,000, was not too big a change for you guys, but in the end, that is totally up to council and what you think is best.
Any other questions on item 6A? Okay, seeing none, we'll move on to item 6B. Discussion related to adopting ordinance number O-2020-0016, amending section 44-14, noises as public nuisances of chapter 44, miscellaneous offenses and provisions of the Code of Ordinances, City of Lamarque, Texas. This will be the first reading on this item, and I'm going to ask our police chief to discuss this one.
Good evening, everybody. If you recall, in May of 2017, this ordinance was brought before council after several calls and complaints from neighbors about noises in their neighborhood. And the ordinance as it reads does not address or prohibit any kind of unreasonable noises in residential areas. Our ordinance does specifically talk about loud music from cars, loud music from residences and businesses, as well as horns, but it doesn't address, and if you recall, we recently had a citizen who was complaining about a neighbor who has a very loud, muscle car type of vehicle, and he starts it up in the neighborhood and disrupts the neighborhood, and that's the disruptive sounds that this ordinance would address. And it was requested that I bring it back before council after some complaints from the citizen. So what this ordinance does is it addresses, and it adds to the noises as public nuisance, noises and sounds in the neighborhood which will that disrupt everyday peaceful lives, and just makes it difficult to enjoy your peace and quiet in your home. To summarize what the changes in the ordinance is, that would be it. It's just to make it easier, increases prohibitions on people making unreasonable noises in their neighborhoods and disrupting everybody's ability to be comfortable and peaceful in their homes. We did do some changes to the ordinance since it was last before council. Dara put in some language, and I'm not an attorney, so I would let her speak to the reasons why those specific exemptions were listed in this ordinance. Dara?
So those exemptions are just things that typically come up that need to be exempted. So you don't end up with, an unclear law as far as the public is concerned. There are certain things you just expect to break kind of a standard decibel level. For instance, construction sites that are within the allowed hours, emergency vehicles, that type of thing. So we're really just rounding out the ordinance.
If you would recall, previously I had complaints from people who were 2 o'clock, 3 o'clock in the morning while they're asleep in their homes. They're getting their neighbors are coming home, slamming doors, hooting and hollering in the neighborhood and waking everybody up. That's what we're trying to address here, and understand that this is responsive to complaints from the citizens. This is not the police department or the city attempting to create more restrictions on our residents. This is responsive to complaints from our citizens. So are there any questions from council on this?
So the biggest changes to it, Chief, are just that section about unreasonable noise, or the 2 paragraphs about unreasonable noise in different environments.
Correct. The unreasonable noise in residential areas and areas zoned as commercial and industrial. Yeah, it's just making it so that I guess, you know what, it's not against the law to be a rude person, but I guess this does make it against the law to be a rude and sensitive person who doesn't care about other people's ability to live peacefully in their homes.
Thank you, Chief, because I'm firsthand witness of some of those folks that were complaining. And at least it gives you the right to address it. Thank you.
I think one of the biggest, just adding to what Chief mentioned here, I think one of the biggest concerns we've had with this is these last 2 individuals that I can think of for sure, that have complained about situations numerous times. Both of those individuals were individuals dealing with PTSD, and the loud noises, and it was driving them to the point of not being able to handle it. And in one case for sure, we believe the neighbors were doing it intentionally, just because they knew it was making them mad. This was, you have the right to some privacy in your home. If somebody's sitting right outside your window, revving up a muscle car just to irritate you, we need to be able to address that.
Chief Jackson, I'm a little concerned about some of this. I'm willing to go with you on this one, provided that in a year's time we would be able to do some research to see if this brings any issues forward. I'm just a believer that our laws and our ordinances, they have to be filled with common sense, but they can't be gray. They have to be black and white. And a lot of the language that's put in this ordinance is a lot of stuff that basically says, and I'm just paraphrasing, it basically says, if you are doing anything that is unnerving to your neighbor, that perhaps you might be violating our noise ordinance. And it's basically at the discretion of the complainant and the peace officer, who perhaps would not even be on the scene at the time that the ordinance was violated. There's a lot of gray in it. One part of it says basically you have to have a permit if you're going to have any amplified sound and things of that nature. But the other part of it says that this ordinance can't infringe on the rights of any free speech. And so to me, it's unclear in a lot of different ways. Part of the ordinance says that if a person were to honk their horn outside of someone's home in a residential area, that is a violation of the ordinance. And so I know that you're trying to solve a problem. I do. And I can go with you on that. I know that we've had a lot of complaints, but I really think I really want us to really be careful with this ordinance, and I want us to look at it closely to see exactly what sorts of issues it presents for our citizens. Because while we have, I'm sure, done the best that we could do with this ordinance, it's very gray, and it might cause more problems for some of our residents than we anticipate. Let me ask you this, Chief. Last question: would this ordinance apply to roosters?
So the ordinance, and actually, let me touch on a few things that you said. The ordinance affect prohibiting honking of horns. That's already in the ordinance. The provision of a permit for sound amplification, that's already in the ordinance as well. That was passed because as our ordinance was written a couple years back, events such as churches having a festival, those would have been prohibited under our city ordinance. So we added in provisions that would allow a permit for sound amplification in certain situations. So that's already in here. That's already prohibited. The only change that is being presented with this revision to the ordinance is the unreasonable noise in residential areas, and it talks to a person of normal sensibilities. So it's not just if somebody complains. I mean, there has to be noise that is interrupting a person of normal sensibilities. As far as roosters go, there already is the provision in here of keeping any animal or bird causing a frequency or long continued noise plainly audible at a distance of 50 feet or more. That's already in our ordinance. That's not being added or removed from it. That's already in the noises as public nuisance ordinance that the city has.
I appreciate that, Chief, and let me just push back a little bit. I know that these things were in this ordinance. I've read the ordinance before, but anytime that we as a council consider ordinance changes, in my opinion, in my understanding as a council member, what needs to happen is there needs to be an overall observation and an overall evaluation of the entire ordinance. So while something was workable in, for example, 2010, it might not be workable in 2020. Ordinances, Chief, as well as laws, are living documents. They live and they grow based on what's happening during the time in which we live. And it might be beneficial to have this in our ordinance in this year, but 10 years later, 5 years later, maybe even 2, we might find that hindsight is 2020, and we may not want to continue with that. In this climate, the climate that we have with folks that are so frustrated with one another and fighting one another and things of that nature, I'm just saying that we need to look at things that have already been in the ordinance. I do know that. But also the new things that you placed in the ordinance. We need to look at all of those things to make sure that our ordinances are speaking to the people at their needs in this moment in history. The only thing that I have not an issue, I have a concern about is this idea that much of the new language in this ordinance is based on the discretion of the complainant and the affirmation of the peace officer. And that's where I think that we're going to get into some problems. And I don't know, to be honest with you, I don't know how you solve that. I'm not suggesting that you have done anything that we know will cause us problems. And so that's why I'm saying I'll support you on this. But I'm saying that may be an issue for us, and I don't know how y'all plan to look at that. I don't know if we bring Judge Baker into this conversation, but I just like to see a year from now. I'd like for you to be able to come back and tell us exactly what the effectiveness of this ordinance has been. So that's all I have. Of course, like I said, I'll support you on this one. I just want to make sure that we're keeping track of what's actually happening in the neighborhood.
Mayor Pro Tem, following the reading of the second ordinance, I will go ahead and start compiling data on any of violations that might possibly be written under this ordinance, and bring it back to you in a year. Would that be acceptable, sir?
Yes, sir. Yes, sir.
Mayor Pro Tem, just adding one thing here. Chief Jackson and I had a number of conversations about one of the complainants in particular. And we're talking about, about the quote unquote shades of gray versus having a direct cutoff line. There are some provisions where you have to reach a certain decibel level, but then when it's happening, somebody has to be there with a decibel meter to read it. And we kind of went back and forth about some of that stuff. And the officers that went out there and talked to him, I think that they had enough information in front of them to know that what that other person was doing was meant to intentionally disrupt this other person, or was meant to be a problem, but there was no way to verify what the actual level of the noise was, because it was on a recording where he had taken a video or he had taken an audio recording. And so I think the officers, they know those trigger levels in the law when it comes to, what levels of audible are normally considered to be, too much, and what will trigger those things. And so I think this ordinance gives them, if they can go look at a video, and then guys taking a video at 4 o'clock in the morning and somebody's outside of their house revving up the car or something, I think it gives them the ability to actually address it, rather than just going next door and saying, hey, I saw the video, you probably shouldn't be doing that if it's reaching decibel levels above this, but they really can't do anything about it because they don't have an actual instrument that was there at the time that recorded it. And then all that's going to do once we have with this situation, all it's going to do is make that person that was doing it to annoy the other person even madder, and they're going to continue to do it more. So I think it does give the officers more room to actually try to resolve some of these issues under the ordinance, rather than just making them worse by trying to talk to the people that are involved. But yeah, definitely we'll put it on the calendar for if it passes on second reading, we'll put it on the calendar for a year from now to talk about it again.
Thank you.
I'd like to, well, actually first, I see Dara has been trying to say something here for a while. So Dara, I'll talk after you.
It sounds like it may have been handled. I just wanted to say we did do a little bit of research because I have dealt with cities on both sides of the line, the ones that use the reasonableness standard, which is not quite as gray as it sounds. It's a very standard legal concept. And we did actually touch base with our prosecutor on it before doing it to see if a decibel level would be more effective for what we're looking for. And we're actually told that the reasonable standard has been working very well in other cases, because we're literally using a jury made up of people from this area who are making those decisions. So they seem to feel like they actually suggested that we stick with the reasonable standard, not a decibel level. And then touching base with cities that use the decibel level, they did express concerns in actual enforcement that they were having trouble with the court trials becoming something like DWI trials, where it became about when you had calibrated the decibel meters and how many were taken, where were you standing, etc.
So I want to add my feelings to this gumbo, and I want to say I feel very similarly to Mayor Pro Tem in that there's a few things here that just, they perked my ears, mainly in that I was recalling some of the grief that I know the PD had incurred earlier this year with some particular problems with some neighbors who were almost using the PD as a way to just agitate one another, like calling the cops on each other over and over again. And that's the kind of thing that seems to me like that's a perfect way to abuse this ordinance, is to say that someone is being, unreasonably loud and disturbing your peace and quiet. And it just made me wonder if there was things we could add to the wording that would help define that. It sounds like that's a sticky wicket, which I understand. And also, to follow up with that, my question is, what's the direct impact? Like, can police officers charge someone just by having someone call in and say, hey, they're revving their muscle car outside my window? Like, I'm assuming that doesn't then immediately lead to, okay, you're going to be charged with violating this this law, but there needs to be video footage. I just would like some clarification on how we end up to the stage of the cops aren't just arriving to say, hey, you need to sort this out because you're currently violating, we're going to tell you you shouldn't be doing this. What's the difference between that and then actually charging somebody with something?
As with all calls for service, we're not going to take any enforcement action until we have, or unless we have some corroborating evidence, corroborating statements, and merely saying they were revving the car. That's gonna trigger some follow-up and investigation on the part of the officer. As it is right, as Mr. Jackson mentioned, as it is right now, if you're sitting out there revving up your muscle car out in the driveway with straight pipes, I don't even have the grounds to go over and address it. But now I do. So now that we have the verbiage in the ordinance, that allows the officers to have some ability and authority to follow up on these complaints. We don't just file charges arbitrarily. We don't give people tickets arbitrarily. We only do it after we've established probable cause that a violation has occurred. So it's not going to be just they were being loud. Okay, well, let me go write them a ticket. I mean, there is follow-up, there is investigation that the officers will conduct before determining whether or not probable cause exists for criminal charges or violation of city ordinance to be filed in municipal court.
Okay. Well, I agree. I think it would be great to have the data of what I reiterate with what Mayor Pro Tem said. I think that would be a great way to keep an eye on it because I totally understand the need for it. But it's tricky. Thanks.
Any other questions on item 6B, excuse me. Okay, moving on to item 6C, discussion relating to providing direction to the public relations specialist on the development of a draft 3-year communication plan. I'm going to have Colleen talk to you about this one, but I'm going to give you a little bit of foreground so she doesn't have to. When we started the Certified Public Management Scholarships last year for the employees, Colleen asked if she could go through a program that was more similarly situated to what she does for a living, which was a Certified Public Information Officer program that was offered through, I believe it's through Texas Tech, if I remember right. She's going to give you a little bit more information on that, but that's kind of where this came from. This is a class project that she has to do to get her certification. And so she asked about bringing it to council to see if council was interested in doing this as a full-fledged real project for the city, or if it was going to be a mock exercise. So she's going to talk to you guys about it so you can tell her what you think about it. So Colleen, it's your turn.
Thank you, Mr. Jackson. Hello, council. So as Mr. Jackson mentioned, I'm enrolled in the Certified Public Communicator program through TCU. So I'm a horned frog. And the program was on a wait list actually, and COVID opened up a couple of spots, which is why you haven't heard about it yet. But I go off our strategic plan, our 2015 and 2022 strategic plan. I use that as a model for almost everything I do with the city. And inside the plan, you can see in your packet the 4 critical issues all led up to a priority, which was development of a communication plan. So when I started the program and found out a deliverable was a communication plan, a 3-year communication plan, I wanted to just come to council and ask if this is something that you would be interested in doing. It is was set as a priority in 2015. And if council is interested in doing it, then I do have some more questions about developing an ad hoc committee. And the point of the ad hoc committee would just to be to provide direction. We would do some case studies. We would have some focus groups. And of course, at council's direction, we could bring it back quarterly, or we could just present a draft plan at the end of the program. So I'd be happy to answer any questions that you have. We do have a lot of, it's through TAMIA, which is the Texas, every public information officer in Texas is a member of TAMIA, which is through TML. So Sarah Osborne Greer from the city of League City finished this program last year. They implemented this model in the city of League City, and it's doing quite well. And I do have a lot more resources, but I just really want to get the feel of council and see if you would like for me to do this communication plan for Lamarck.
Colleen, I think it's a great idea. I'm glad that you're doing it. I'll be glad to help. All you need to do is reach out. I think if you weren't there and we were hiring somebody new, I think this might be a requirement for them. Yeah, it's a good deal. Thank you.
Thank you, sir.
I agree. It's spectacular. I'm so excited. I can't wait to see the work you would put together on this. What a coup for us.
Thank you. So I have a list of 18 people, 9 are internal, 9 are external. I'm happy to share that with council, or can, however you want to proceed. I just wanted to make sure you wanted to do it before I kept going.
Add my name down there. I'll
Yes,
join you.
sir.
And that's your list of 18 is for this ad hoc committee to help.
Yes,
generate
it's
all
just, and it's ad hoc, so we can add and take away and change as, throughout the year, whatever council wants. It does have some people from the community, such as Kathy Thomas. She is the owner of Communication Strategies. She is the contract for Gulf Coast Water Authority. Some people like that. Of course, Melissa Tortorisi from TCIC. So this program is not only for cities, it's for all municipalities, county level, state level, school districts, etc. So Melissa Tortorisi, and then we have some members from some boards and commissions on the list, and yes, some local business owners, someone from the chamber, so, and all of council.
Yeah, I would love to be a part of it. I would love to join when I can. That's great. How exciting.
Any other questions or comments or suggestions on item 6C? Okay, whenever you're ready to roll, Colleen, just let us know what we need to do.
Yes, sir. Thank you. Thank you all.
Item 6D, discussion relating to preliminary plat for trails at Woodhaven Lakes, section 1. This will be Ms. Purnell.
So putting on the other hat from the development side, this has already been through the Planning and Zoning Commission. This is a preliminary plat. As you know, the legislation changed just a little bit. So now when you approve preliminary plats, they automatically come with the condition, if the plat is totally clean, as recommended by ADICO and the Planning and Zoning Commission, that a final plat be submitted compliant with Chapter 41 of the City Code of Ordinances. So that is what we're recommending here. Both the trails at Woodhaven Lakes and the Ambrose, both of these are preliminary plats for a section 1. Council's been looking at them recently as general plans and as planned development districts. One big change on the trails at Woodhaven Lakes is that when the plat went through Planning and Zoning Commission, there were quite a few conditions, and those have since been addressed, and ADICO is now recommending approval.
Any questions or comments on item 6D? Okay, item 6E, discussion related to preliminary plat for Ambrose, section 1. Dara, anything additional to add on it?
This is basically the same type of thing except for the Ambrose development.
Any questions or comments on item 6E? Moving on, item 6F, discussion relating to utility billing late fees accrued during the COVID-19 pandemic. This is the item that you all requested, or that was requested at the last council meeting to be added to this agenda. I sent each of you a memo this afternoon with some options as discussed with staff. We can either go through the options here, or we can do it in the regular meeting, whichever you all prefer. It doesn't matter to me. So I'll open it up for discussion now. If you want to discuss it now, we can, or if you want to do it in the regular meeting, we can do it there, or whichever you guys prefer.
Well, take the discussion now. One of the things I noticed in there is it's hard to put an ending date on something like this, but I don't think it's a good idea to leave it open-ended and and if we clarify and say that, well, to the end of the pandemic, who knows how long somebody can carry that as an open item, at a federal level. So I think we should be looking at something a little more finite, to help the people out that were hit immediately. And once those support payments started kicking in and the additional unemployment, I think that made up that gap. But there was certainly a need, I'm sure. But I wouldn't want to see it just open-ended.
Well, I don't want to see it open-ended either. But I must say, I heard Tink in your, I didn't hear, I read, Tink in your memo, I read that you spoke about this this stimulus package that was passed, and I assume that speaks to certain businesses that are in Marque that receive stimulus, perhaps to get them through a difficult period. And then you talked about this boost in these unemployment benefits. And while that looked like a tremendous boost, maybe for those of us that didn't get it, because we kept our jobs, or perhaps we were able to survive in our businesses, at the end of the day, that extra money went to people who were at home more, right? And so while they were at home more, they used more lights, they used more gas, they ate more food, and of course they used more water. And so those unemployment benefits went right along with that extra time that they spent at home using more than what they would normally use in their resources. And many are still at home. Many are still not working. Many are still unemployed. Many children, although there's an option, I understand that, but many children are at home because parents are afraid to send their children back to school because it just seems like we haven't been able to get a handle on this virus. And the other thing is the stimulus portion, along with these unemployment benefits, these extra benefits, all of that's gone. And we could see that all of it's gone because this council had to ratify twice grant funding that our EDC provided for the businesses within our community. And many of you might know this, but I know this because I served on the committee. Many of those businesses had to apply for the grant funding twice. And so this stimulus, this unemployment, it didn't run as far as we probably, those of us that didn't get it, as far as we think that it ran. But I will say this, I'm not for an infinite amount of time. Obviously, we can't do that. I am interested in number 2 is a great option, and number 4 is a great option. I believe if we can find people, or if people can find us and prove to us that they have been laid off or terminated or furloughed, I believe that there's an opportunity for us to make a deal that we might be able to quantify. And we can, I'm not opposed to putting time limits on this on either side. I understand that this is a city, but I did want to say in the future, think one of the things, and I know we've done it, but now's the time that we might look at it. We have actually factored in our revenues $200,000 of late fees because of late water payments. That's like betting, and it's an educated guess. That's like betting on our citizens to default on their agreement with our utility services. And while that happens, and we know that happens, I don't know moving forward. And yes, we approved the budget, but I don't know moving forward that that's a good idea for us to continue to factor that in as a main identifiable source of revenue. But otherwise, I think there's a deal to be had here. I think that we can definitely negotiate, and I'm open for us to figure out what we need to do.
Yeah, a couple of comments about real quick about the options that we put together. So there's a huge concern or on the amount of time and effort it would take to make this to do this back in the past, because we just crossed fiscal year boundaries. So now if we went back and said anybody who has accrued late fees right now back to May, we're going to waive those. Well, now anybody that paid late fees from May till now, we would have to go back and refund those as well, or we're not giving equal protection to everybody, which would mean now we're impacting our financial statement, which has already been done by the auditors from last year. So we have to call auditors back to review everything. We'd have to redo everything. So going backwards is a tremendous amount of work. It would take a lot of work and would be very problematic. There's three options that were presented in the memo that would not require any backward movement, and that's options 1, 2, and 4. One with the temporary reduction in approved late fees. That one would apply across the board, obviously to everybody. There would be no requirement for anybody to come in and show an impact or show whatever. But we could do a temporary reduction from this point forward. We'd need to do it because our late fees are adopted by ordinance. We'd need to do it by ordinance. But we could do it where it says from now for the next however long or whatever period of time you guys come up with, that we're going to reduce our late fees from 10% to, we have 7% in here, but to some percentage. That's one option. Two would be the second number 2 option would be just to waive the late fees straight up from now until the end of the pandemic, which of course, we don't know when it's going to end. So that, it could be from the next 3 months to help people, the next 6 months to help people, whatever time frame it was, or until the end of the pandemic. There's not a definite known what the impact would be on the revenues from that. But that's an option. And then the third one is the impacted late fees. So if we could come up with a program where somebody could come in, show us their paperwork from the Workforce Commission that shows that they were laid off during the pandemic. And then as a result of that, we would go back and look at adjusting their late fees. So there's a number of options we could look at in there. Whatever you guys want to do, of course, it's up to you. I think 1 and 3 have the least impact on staff time. Of course, 4 takes a little bit more time with staff because somebody has to review those applications and look through them and make the determination if they have the documents to go with it. But I just wanted to give a little clarification on those. And then the other thing, since the beginning of the pandemic, we've not disconnected anybody for non-payment. During a pandemic or during a declared declaration. That is not a normal process to declare or to disconnect anybody. I think my other concern in this, when we talked about timing, is if you don't put an end date to all of it at some point, if this thing lasts a year, 2 years, 3 years, then all of a sudden it ends. And now these people haven't been making any payments whatsoever, doing anything. Now all of a sudden they've got this huge bill, and we got a whole bunch of people with this huge bill because they didn't have to address it because we waived the late fees and it wasn't going to change if they didn't. And I'm not saying that there's some people out there that probably don't have the means to pay any of their bill right now, but I think some of these people have a means to be doing something. At that point, we're going to have a year or a year and a half worth of bills, and we're going to be out of the declared disaster. It's going to come back to doing cutoffs, and then we're going to have all these people flooding in with a $1,000, $2,000, $3,000 bill they can't pay, and then what are we going to do? So that's something else we considered in this is not pushing it too far down the road because we didn't want anybody to get in that situation, and then what are we going to do when it gets to that point? So just some thoughts on what all we were thinking of as we went through this and talked about putting this memo together to give to you guys for options. So whatever other questions you have or whatever, I'll be happy to try to answer your questions.
Tink, without asking a whole lot of work from our utility billing, if there would be a way that we could bash our rental properties up against our late payments, I think that would be significant because, what you expressed there is a real concern about people not paying and then they move and they're gone and they're out of the city, if rental property, that does happen. And I do know that I would see that as a problem.
I see that historically too. We'll take a look at that and see how much work it can take to figure that out.
But that happens. That always happens. That's happening now. That happens in every city. That has absolutely nothing to do with the conversation that we're having right now. And this conversation is, how do we, as a city, use the resources of the taxpayers to help our citizens out in a pandemic? And think you're exactly right. It does need to be limited, and I'm willing to go with you on that. And we can every 6 months, if we have to, we can reconvene this. But I think I applaud you for bringing these 4 options to us, because it took some thought and foresight. And I think we got a deal. I think we can figure out something out of these 4 options.
I have a question. So, as a way to try to balance helping those most adversely affected and also efficiently use staff time, could we do some sort of hybrid of like option number 1, where there is an equitable sort of reduction across everybody? And then for those who, you know, who lost, like if we had some very, very defined, you know, trigger points of they lost their job and they can prove that, or, you know, I don't know, some other things that we thought were, you know, important enough, relevant enough, and they could come prove that, then that triggers a certain waiving of fees from that point forward on. Because I do hear you that like it seems like it would be such a bear of staff time to go back retroactively. I guess I said that twice, but
You're talking about a combination of 1 and 3, of options 1 and option 3 is what you're talking about.
I suppose.
No, or 1 and 4. 1 and 4. Excuse me.
4, yeah.
I guess so, yeah. Because I was thinking, you know, it seems to me if we were to do just that, people have to come in and bring some evidence of their need to have their fees waived. That in itself sounds like it could just turn into just a real clog for staff. And not only that, but also turn into something that could be a burden on those households, right? Because I mean, some people may have been really affected, but they can't point to, I lost my job, or, you know, they might've been able to keep their job. No one got sick, but still everything worsened. I mean, I think we're all pretty familiar with that, you know, reality. So it would be nice to say for everybody, we're going to lessen this burden on everybody right now to try to show understanding as a city. And okay, for those who really were adversely affected, if you're able to come and prove 1, 2, or 3, and only these things, then we'll give you even more dispensation. But try to remove like the gray areas around that so that there's less back and forth between staff and individuals. I don't know, just a thought.
I think there's a plausible way to put 1 and 4 together. You know, somebody who lost their job for a month, but got their job back quickly or found another job or whatever, you know, maybe, you know, the item option 1 helps them catch up a little bit, where they wouldn't necessarily qualify for option 4.
Mm-hmm.
But somebody who was laid off at the start of it that is still being impacted by a layoff and hasn't gone back to work, option 4 may still be, you know, option 7 is going to help everybody who is impacted and is not paying their bills, but it's still going to keep those that have the ability to pay their bills paying them, because they're still going to have late fee. But then the ones that have really been affected, option 4, I think would give us a little bit more leeway with them.
May I say something?
Go ahead, Susie.
Okay. If you want option 1 to change the percentage from 10% to 7%, in the system, it applies to either all or none. It cannot be a selected group because it is a setup inside the system, the utility system.
Yeah, so that's what we're talking about. Option 1 would be for everybody. But then option 4, if they had lost their job at the onset of the pandemic and they were still unemployed, and they can bring us proof of that, which is very easy because they can bring us their workforce forms and we'll be able to see. I mean, that's easy to prove. Would not take them very long to do it. Then we could look at option 4 for some period of time.
But if let's say they found another job, are they required to come back and notify us? What if they don't? Are we
Well, that's what,
assuming?
that,
I think
well,
that's
because they're
probably
gonna show that they've been unemployed for probably 6 months or 4 months or whatever it is. So if we do this, when it's a 3-month window, then even if they did find another job right after, the impacts would still cover the impacts that they had when they were unemployed. I think that's what you're getting at. So if we do it for short term, and then at the end of the 3-month period, do it for 3 months. At the end of the 3-month period, look at it again and tell everybody you still want it. You got to come back in and show us that
Yeah.
you're still not working.
Yeah.
That's
I like
good.
the idea of making it, trying to balance the burden on everybody.
So are we just limiting to just being unemployed, or are we also allowing those with, let's say, a family member got infected with COVID and they have some financial difficulties? Are we helping those as well?
We'll be up to council.
You know, it can be subjective too.
Yeah, I think you at this point, Susie, with everything that's been done, in my opinion, we go with those that have been furloughed, laid off, terminated through no fault of their own, simply because this program can really get out of hand. And I think that the heart of this council is to help our citizens without hurting our municipality. So, in my opinion, it has to be limited in scope at this point to unemployed, laid off type people.
We could okay, Daryl, timing wise, we could draft that really quick. If we had a special meeting, how does the emergency clause work here? If we put an emergency clause in it, can we do it on first reading?
Yes.
Okay, so we could theoretically call an emergency or a special meeting on Thursday or Friday or next Monday and real quick approve that ordinance and implement it. It only take us a week to get it implemented.
Correct. And honestly, the difficulty of drafting the ordinance will just depend on if we're using only concrete proof using workforce forms, then you can move pretty fast. If we're trying to add additional requirements on there, that's going to take a little longer to come up with the forms behind it. But yeah, we can definitely have that ready pretty quick.
And that's why
Okay.
I think I agree. I really think that the hybrid of that only works if we can say we're trying to help everybody by reducing fees overall. But if you can prove this and this, very concrete, specific things that keep it easy on our staff, then we'll completely waive for a limited amount of time.
Okay, so to me, the two requirements on number 4 are you have to prove that you're unemployed and can remain unemployed. And 2, you have to prove you live here in the city, because I can see people who live outside the city coming over here and trying to say, oh, I live at that house, to try to help them get the reduction in their fees. So does the utility bill have to be in their name, or they have to, if the utility bill's in mayor's name and he didn't get laid off, but Mrs. Mayor did get laid off, that qualifies?
Well, that brings back into the rental property, Tink. There's some landlords that pay for the utilities. They
We're gonna have to,
rent.
but they'll get the number 1, but they wouldn't be able to apply for the other.
Correct.
Correct.
Yeah. We got to protect against that kind of abuse.
Yeah.
And the other thing, Tink, is this. They are those that rent property in our city, when they go to get their water service turned on, it's my understanding that they're supposed to be providing a lease.
They should be.
And so on that lease, I would hope if I was a landlord, everybody that's living in that house needs to be on that lease. And so if the water bill's name is in Tink Jackson, but Tina Jackson got laid off, we should be able to go through Tink's lease. Oh, okay, that's Tina. Okay, we got you. And we should be able to settle it like that.
Is that how
Okay.
that works?
So, but the point being, if the water bill is in my name, but there's somebody else in the house that got laid off, we're still going to waive the entire fee for that address?
If that's what I don't have, I can go either way on this. I'll whatever the majority of council thinks. I'm simply saying, if we choose to go that way, there's a way for us to be able to find out, even if their name isn't on the account. We should already have in our possession the ability to look at their ID and match it to the lease agreement that they turned in. Now, if council doesn't want to go that route, I'm willing to not go that route with them.
There'd be a whole lot easier to draft it if it said that it had to be in the utility owner's name, right? If the utility owner had been laid off or utility account holder.
Definitely. Can I ask on the Texas workforce forms? I haven't seen those in some time, but do those have the address listed? Because that should actually match up.
I think they do.
That might be an easier way, simply because you're talking about a lot of background information research on the part of utilities. Even if the lease is assuming that the city keeps that lease when someone applies for the account, which I don't know that that's the practice. I think it's just proof that they actually have a lease and are authorized to live there. That's just a huge amount of background research to try to verify this information. So if the utility billing department can just use the Texas workforce form, as long as the address matches up, that would keep it pretty clean and is I'd say less open to misuse than some of the other methods.
Yeah, I think that's going to work because when Texas Workforce sends something out, it's just like something we send out. It's tri-fold in a windowed envelope, so the address is going to be on there. They don't label each one of those envelopes. It's automatically printed on the document, so it'll have that. It'll have their address on that document. And then the only problem is that they're using a mailbox.
Yeah, if I could weigh in on this, I'm in favor of number 1 and the hybrid part of number 4. But I think it ought to be based on the workforce, because if they're at that address, they were probably helping pay the water bill. So why wouldn't they need the money? So based on that, when we get to this item, I'll have someone motion to, I guess, table it, and we'll bring back for the special meeting.
Yeah, and then we can just set a special for a week from tonight, and we'll have the document ready if we know. Or you can do a motion to draft, and you request staff to draft an ordinance that's a hybrid of 1 and 4 with the parameters discussed, and then we'll set the special meeting and come back and approve it.
Okay. Thank you for the research and the work you guys did on that. That made this discussion a lot easier.
Any other discussion on item 6F? Okay, Mary, that's it. Oh,
sorry, to clarify for the ordinance, we are planning on this applying to the next billing cycle, correct? So we don't create
going forward.
Yes.
Going forward from the vote next Monday night on the next billing cycle. We good?
That's it, Mayor.
All right. Well, it looks like we still have our quorum and our all 5 members here with us. So we'll move into the October 12th, 2020 regular meeting, calling it to order. And item 3 is the minutes. A, workshop council minutes of September 14th, 2020. B is regular city council meeting minutes of September 14th, 2020. C, special city council meeting minutes of September 15th, 2020. And D, special city council meeting minutes of October 5th, 2020. I'll entertain a motion.
So moved.
I second.
Motion and second. Any additions or corrections to the minutes? Hearing none, I'll call for the vote. All in favor?
Aye.
Aye. Any opposed? There's one item under the consent agenda that we spoke of, and it's the expenditure of the $66,930 from the CARES Act funding for the mask. I'll entertain a motion.
So move.
Second.
Motion and second. Any further discussion? Hearing none, I'll call for the vote. All in favor?
Aye.
Aye.
Any opposed? Item 5 is a new business. A, discussion possible action regarding adopting ordinance number 0-2020-0015, amending Chapter 2, Administration, Article 4, Purchasing of the Code of Ordinances of the City of La Marque, Texas, and adopting an updated procurement policy. This is the first reading, and I'll entertain a motion.
So move.
A second.
There's a motion and a second. Any further discussion?
Just real quick, Mayor. Dira, I'm having heartburn with this no bid, this ability to award no bid contracts with $49,999 up from $25,000. Because I don't know if that opens the door to some things that we may not want to deal with. How do you feel about that? Is this absolutely necessary for us to apply for grants? Just really quickly, in 2 sentences or so, just kind of help me out so that I can move forward.
I do advise it. I think it's going to allow staff to pay closer attention to some of those smaller requirements, such as making sure that hub vendors are truly included in the process for all our purchases. I'm happy to speak more if you want.
Is there any way we can police the, for example, if there are expenditures at $38,000, $39,000, $50,000, $45,000, is there any way that council can be alerted to those? In other words, does that make sense? In other words, if it happens, is there any way that Tink would shoot us an email or something to that effect, so that we can at least be aware of it until I can get comfortable with it?
Sure, or we could have Susie just add in a 1-page document in the budget in the packet each time that shows what those were and what they were for.
Okay. Yeah, that's
over 25, so you can see what's being done between 25 and 50,000.
There you go, until I can get comfortable with it. If we do that, I'm good.
Can do that.
Any further discussion? Hearing none, I'll call for the vote. This is the first reading. All in favor?
Aye.
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 Any opposed? Show the motion passes. Item B, discussion possible action regarding adopting ordinance number 0-2020-0016, amending section 44-14 noises as public nuisances, chapter 44 miscellaneous offenses and provisions of the Code of Ordinances, City of Lamarque, Texas. I'll entertain a motion.
So moved.
There's a motion. Is there a second? This is the first reading.
I second.
There's a motion and a second. Any further discussion? Hearing none, I'll call for the vote. All in favor? Any opposed? Show the motion passes. Item C, discussion possible action regarding direction to public relations specialist on the development of a draft 3-year communication plan. We've discussed this. Seems to be favorable, but let's go ahead and get a vote. I'll entertain a motion.
I move that we, I second it.
Yeah, motion and a second. Any further discussion? Hearing none, I'll call for the vote. All in favor?
Aye.
Aye. Any opposed? Show the motion passes. Item D, discussion possible action regarding preliminary plat for the trails at Woodhaven Lakes, section 1. I'll entertain a motion.
So moved.
Second.
There's a motion and a second. Any further discussion? Hearing none, I'll call for the vote. All in favor?
Aye.
Any opposed? Show the motion passes. Item E, discussion possible action regarding a preliminary plat for Ambrose, section 1. I'll entertain a motion.
So moved.
There's a motion. Is there a second?
Second.
Motion a second. Any further discussion? Hearing none, I'll call for the vote. Item F, discussion possible action regarding utility billing rate late fees accrued during the COVID-19 pandemic. Ms. Dara, how would you like this motion made?
So it sounds like at this point, council is just motioning to provide direction to staff that you want a combination of options 1 and 4 as discussed, brought back to you as an ordinance.
Yes, thank you. Thank you very much. And so with that wording, I'll need someone to make that motion.
I move that I
Yeah.
request that the city staff put together a hybridized version of the plans they gave us today so that we can vote on it in a special meeting soon.
Thank you. And is there a second?
Second.
Any further discussion? Hearing none, I'll call for the vote. All in favor?
Aye.
Any opposed? Show the motion passes. Item 6, under appointments. Anyone have any appointments or reappointments this evening?
I do.
Yes, sir.
I would like to, and I'm gonna need to get some help on this address. So I'd like to appoint Cleveland Lane as the District A representative on the Economic Development Corporation. And Chris, Cleveland Lane's new address is
1943 Duro, I believe.
1943 Duro.
Thank you. An excellent choice. Any others? Then we'll go ahead and vote on that appointment. All in favor?
Aye.
Aye. Any opposed? Motion passes. Item 7, executive session. The City Council for the City of Lamarck, Texas reserves the right to adjourn into executive session at any time during the course of this meeting to discuss any of the matters listed. Tonight, under A, we'll go back under section 551.017, consultation with attorney regarding pending litigation or settlement offer related to contract and employment claims of William Reed. Madam Clerk, will you call the time, please?
7:21.
7:21, we'll adjourn the regular meeting and go into executive session, and we'll go to the Bat Cave now. So join breakout room will be your option. See you there. Kyle, can you remove that logo? Thank you, sir. This time, Madam Clerk, will you call the time for us reappearing in the regular meeting?
She was having some audio issues. It's 7:40 p.m.
Yeah, I'll call it for the record then. It's 7:40, coming out of executive session back into the regular meeting. Item A, discussion possible action regarding pending litigation or settlement offer related to contract employment claims of William Reed. I'll entertain a motion.
I move that we accept the settlement proposal.
There's a motion. Is there a second?
Second.
There's a motion and a second. I'll call for the vote. All in favor?
Aye.
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 Show the motion passes unanimously. At this time, I'll entertain a motion for adjournment.
So moved.
I'll second. There's a motion and a second. All in favor?
Aye.
Hey, listen, you guys, I appreciate your thoughts and prayers for my wife. It's been a rough week. It's still rough, but I really appreciate it from the bottom of my heart. And I'll see you guys, I guess, next Monday night, if that's the night.
We'll get it together by then.
Have a great night. Bye-bye.
Bye.
Aye.